Welcome, everyone. My name is Dan Schrag. I'm the director of the Harvard University Center for the Environment, and it's a great privilege to have Jody Freeman and Richard Lazarus here today to share their insights on these new EPA rules. You know, in the discussion about climate change, EPA regulation seems a little bit down in the weeds, and yet, from my perspective, working on the issue of climate change really for my whole career, the new rules that EPA has issued on stationary sources, CO2 emissions, is probably the most significant, if enacted the way I expect, is likely the most important thing that the US has done on climate change up till now, and will have huge ramifications on our energy system really for decades into the future. And in some ways will potentially move the whole world towards
You're stealing our
the
thunder.
direction of a low carbon future. I am stealing your thunder a little bit. What the problem is we have to get these laws, these new regulations through a contentious legal system, and there will be many legal challenges. And that's what Jody and Richard are here to discuss, to share their particular perspectives. And really, Harvard is incredibly lucky that not one, but both of these experts are on our faculty. They are, in many ways, uniquely qualified to comment on this. Jody has been at Harvard for quite a while, at Harvard Law School, leading the program on environmental law and policy. But Jody also spent almost 2 years in the Obama administration early on, working closely with the EPA on their rules for automobile emissions, and was critically involved in that EPA effort and understands the EPA inside and out. And of course, Richard Lazarus just more recently arrived at Harvard, but while he was in Washington, he at Georgetown Law School, he was really one of the nation's experts, not only in environmental law, but also on the Supreme Court. And so has sort of a special perspective on how the Supreme Court is going to think about these issues. So please don't listen to me anymore. Let's waste no time and welcome.
Well, we're here today because, as you all are aware, in June, EPA announced its proposal for what it's calling the power plan, Clean Power Plan, which is the proposed rule is designed to regulate for the first time in the United States the utility sector emissions of carbon dioxide to address greenhouse gas emissions in the United States. It is a very ambitious rule. For the first time, it proposes standards for the existing fleet of power plants, not new ones to be built, but the existing fleet. As Dan said, it represents the Obama administration's most ambitious policy yet to deal with greenhouse gases and address climate change. It's the companion piece, as Dan mentioned, to the transport sector regulation that was put in place in the first term, the fuel efficiency standards to 2025. And if you piece these things together, you see the emergence of a sectoral approach to greenhouse gas control, sector by sector, using the statutes that you have, and in this case, as we will discuss, primarily the Clean Air Act, because Congress has not equipped EPA or any other agency with a new statute to address greenhouse gases. This proposal is exceedingly ambitious, as Dan said, has the potential to be transformative of the utility sector. It is no less controversial as a result, and it is also really, really long. When it first was dropped on June 3rd, I think it was, Monday, June 3rd, I was on the West Coast. It was 5 a.m. in the morning. Richard was on East Coast time. And we, like all law professors around the country and other crazy people, were up beginning to read the 645-page proposal. This is a rule now, a 645-page regulation, with a 100-page legal memo to further explain its legal rationale in case you didn't catch it in the 645-page rule, and with hundreds of pages of technical support documentation. Thousands, really, as well. And we are here to save you time. Already there have been millions of comments filed. The rule is not even 6 months old. More comments are to come, and the controversy has just begun.
All right, so we're going to have our talk divided into 3 parts. First, we're going to talk about basically the political and historical backdrop for the rule, why the president did this, with EPA, why the president acted alone, as they often characterize it, and what were the events and different actions that EPA took before they proposed this rule. Then second, we want to talk about the rule itself. Describe the rule, so you don't have to read the 645 plus pages. Describe the rule, sort of the structure of the rule, sort of pinpoint what the most significant parts of the rule are, what the most ambitious parts of the rule are. Sort of boil it down to its most essential and important parts. Then we're going to talk about the legal significance of the rule. What's really legally interesting about it, what some legal issues are raised by the rule, and particularly what some of the potential vulnerabilities are of the rule when it gets to litigation, which we know not only going to happen, but as Jody mentioned, has actually managed to already happen, even though the rule is not yet itself final.
So the first question is, why is the president, quote unquote, going it alone? That is, why is he using executive branch authority to implement climate policy? And the simple answer is one I think you all already know, which is that Congress has failed to pass climate legislation. So the last effort was in 2010 when the Waxman-Markey bill that proposed a cap-and-trade scheme, an economy-wide cap-and-trade scheme with a variety of other measures attached, failed to pass the Senate. And since then, there's been no credible congressional effort to do anything in this domain. So the president's going it alone because he feels it's a policy imperative and it's part of his legacy to use the statutes on the books with the executive branch agencies that he controls through appointment power, of course, not in a day-to-day way necessarily, to do something about greenhouse gases. Now, for many decades, as you know, even as the science on climate change gelled, there was really no activity by any presidential administration to do anything about climate change using the Clean Air Act or any other tool. This is true even through the Clinton administration. And the George W. Bush administration, when petitioned to use the Clean Air Act by a number of states and environmental groups, declined to do so on a theory that it was not an appropriate statute to address climate change. And their legal argument was that EPA actually didn't possess the legal power to address greenhouse gases as pollution under the Clean Air Act. And what happened that changed all that was Massachusetts versus EPA, the Supreme Court's iconic decision in 2007. I say iconic because it's one of, the most famous already environmental law decisions ever. The Supreme Court in Mass versus EPA decided that greenhouse gases are pollutants under the Clean Air Act. They are regulable. EPA does have the authority to regulate them, and in fact rejected the George W. Bush administration's reasons for declining to regulate and sent the matter back to EPA. Fast forward a year or so, and there's a new president, President Obama, takes office and begins the process by which EPA takes step by step, decision after decision to begin implementing the Clean Air Act to control greenhouse gas emissions. And the first step was the endangerment finding. That's the legal predicate to regulating under the law. The scientific finding has to be made. Congress has stipulated that a pollutant poses an endangerment to health or welfare. EPA made that finding about greenhouse gases in an elaborate fact-finding process using all the studies to date, the IPCC and other existing studies to document the threat that climate change poses to health or welfare, made that finding, and then proceeded from there largely because of automatic triggers in the Clean Air Act. Once that finding is made, it turns out the Act requires the agency to set standards for cars and trucks for the transportation sector, which have come to be known as the tailpipe standards that we mentioned earlier. And those were set by the Obama administration, by the EPA, jointly with the Department of Transportation, EPA, DOT together, setting fuel efficiency standards. From there, another trigger was pulled. Turns out once you set a standard for a pollutant under one part of the law, it becomes a regulated pollutant for other parts of the law. And so EPA, next step, set a standard for certain stationary sources. Think of firms, facilities, smokestacks that produce emissions. And in particular, it regulated under a program called, inconveniently, but actually literally very accurate, the Prevention of Significant Deterioration Program, which is designed to set standards for facilities that are built in pretty clean parts of the country to make sure that they control their pollution so the air quality doesn't get worse. And EPA's next step was to set greenhouse gas standards for those parts of for facilities that would be built or updated in those parts of the country. And Richard will talk about the litigation over these rules in a minute. This is the background against which EPA is now proposing to regulate the utility sector as a sector. setting standards for the, first it has proposed standards for new power plants, and now this rule that we're discussing today is for existing power plants.
All right. So there are two other Supreme Court cases the court has decided since Massachusetts versus EPA, which we also sort of want you to know about. The first one, move ahead. The first one is American Electric Power Company v. Connecticut. This was a case decided in 2011. And in this case, the court ruled that a bunch of environmental groups in several states who brought a lawsuit to try to get power plants, existing power plants, to curtail the greenhouse gas emissions. They brought the lawsuit under what's called the federal common law of nuisance. They said these emissions amount to a nuisance under the common law, and we think they violate the federal common law. And we think the federal common law can be invoked in federal court to curtail these emissions. In this case, an opinion written by Justice Ginsburg, the court unanimously said you can't do that. You can't bring a federal common law of nuisance action to try to curtail these emissions, because Congress passed the Clean Air Act, and the Clean Air Act has displaced any federal common law of nuisance. The only way you can curtail these emissions as a matter of federal law is bring an action under the Clean Air Act. But Congress has basically taken away the power of the courts to do this as a matter of nuisance law. You've got to do it under the federal statute. You could do it perhaps under state law, but as a matter of federal law, the only way you can do it is under the Clean Air Act. The second case the court decided was just last June. And that's Utility Air Regulatory Group of the EPA. And in this case, what was at issue was the validity of all those different rulemakings that Jody talked about a moment ago. The endangerment determination, the tailpipe rule, the regulation of new and modified stationary sources in these sort of high-quality air, pristine areas. And in this case, the court basically upheld most everything of what EPA did, with a caveat I'll mention in a moment. The first thing the court did was left intact EPA's endangerment determination. The court actually said, we're not even going to review that issue. We think the D.C. Circuit upheld the endangerment determination. We're not even going to review it. So they left it undisturbed. The court also did not at all decide to review, and they left undisturbed the lower court's ruling that EPA's motor vehicle rule was okay, which is a very significant rule in terms of fuel efficiency standards. The court accepted review, though, the legality of EPA's regulation of these new and modified stationary sources in these high pristine areas. And on that issue, the court basically upheld almost everything what EPA did. They said, you're right, you have authority to do it under this, but the court actually will sort of question part of EPA's exercise and interpretation of the relevant statutory provision. And it's the language in that opinion which has become very significant, we think, in litigation expected challenging the Clean Power Plan. And we're going to highlight that language later on. But for current purposes, what's important is, in both these cases, both the AP v. Connecticut case and the Utility Air Regulatory Group case, the court basically embraced the idea that, yes, EPA does have authority to regulate greenhouse gas emissions from both new and existing power plants under the Clean Air Act, under Section 111 of the Clean Air Act. So that is now common ground in the Supreme Court. So now let's turn to the rules themselves. Now, the rules themselves, and this is sort of the layout, sort of why they're so important. And Jody's actually going to describe the rules in operation. But the reason why they're so important, and Dan mentioned this at the beginning, and Jody mentioned as well, is it covers existing power plants. And existing power plants, they are the big ticket item when it comes to greenhouse gas emissions. I mean, here's the sense. You look at electric power. This is just the 2012 inventory from EPA. Electric power produces 38.1% of all greenhouse gas emissions annually in the United States. So that's a big chunk of the greenhouse gas emissions. The fuel efficiency standards are already trying to go after this. Now these standards are trying to go after that. And you can see almost all that, 75% of those emissions are from the coal-fired power plants. So that's a big chunk. So 75%, even though the coal-fired power plants these days are only about 39% of electricity, but they're a much more proportionate sense of the greenhouse gases, because coal produces so much greenhouse gases because obviously of the carbon in it. So that's why it's so important. You actually need to, if you're going to regulate that coal, the way you have to do it is existing power plants, not the new power plants as much as in the first instance as the existing. And that's just the annual increase. If you look at the loadings in the past, what's already up there in the atmosphere, those power plants contribute even a higher percentage of what's already up there. But going forward, you've got to attack that. I like this picture a lot because it shows you sort of where these coal power plants are in the United States. And it's important for the purpose of understanding the rule to realize how they're spatially distributed in the United States. Because it's not as though you see coal-fired power plants, these existing ones, sort of evenly spread around the United States. There's some parts of the country which have many more coal-fired power plants than other parts of the country. And EPA is going to try to take that into account in its rule. The other thing to recognize is not just how they're spatially spread, but also how they're temporally spread. These existing coal-fired power plants have existed and existed and existed and existed and existed. They won't go away. They've been there for about, the average life of a coal-fired power plant is 42 years. And the reason why they're there and they exist so long is somewhat a perverse result probably of the Clean Air Act. Because the Clean Air Act regulates much more harshly in the first instance new power plants than it does existing power plants. So that gives every existing power plant every incentive possible to never become new, but to always be existing. So if you're going to start to regulate, so these power plants were only supposed to, people thought they'd be there for 20 or 25 years, but no one's turning them off. They keep using them. So if you have regulations which regulate only new power plants, you're missing the big game. The big game is existing power plants. And these rules are going after the big game for the first time.
And here's how EPA is playing the big game. What it's done is it's identified a provision of the Clean Air Act that has been used before, but little used and little understood, as a vehicle for getting at the existing power plants that have largely been grandfathered in, as Richard just described. So what is the rule proposed to do? That's what it looks like in the Federal Register. What EPA has done is set an a rate-based emission standard, for each state. Now, stop looking at the map for a minute and look at me. A rate-based emission standard means, if we can translate it into something we can relate to, a limit on emissions that is an intensity goal. That is, how many pounds of CO2 per megawatt hour. It is not a cap on total emissions. It's not a mass-based cap. It's not a volumetric limit, right? It's a rate-based standard. And what EPA has done is express these limits in this way as a rate-based standard, but it's very individualized, so each state has a different standard. And that's represented on the map here. You can see that the darker colored states have a higher intensity target. That's the percentage improvement they'll have to achieve by 2030.
Notice Vermont doesn't have to do anything.
Yeah, Vermont's super happy. Washington's also looking sad, but what you're going to learn in a second is this is a little misleading if you just look at the numbers as an expression of how hard it would be for the state. When I'm going to explain in a moment, we'll give you a little more insight, and you'll see that how hard it's going to be for each state depends on its current energy mix and the availability of other reductions from a variety of strategies they can pursue. So bear with for just a minute. The bottom line is that if these targets, which are set for each state, are achieved, then EPA projects a 30% emission reduction over 2005 levels by 2030. Okay? A 30% reduction in emissions over 2005 levels by 2030. But what you really need to understand is EPA did not set a 30% reduction cap. What they set was targets that, if achieved, will produce the 30% reduction. How did EPA do it? Here's the magic. Oh, I love that slide, but I'm coming back. I love that slide, Ari. Ari's our energy fellow in the law school's energy program and an energy lawyer himself, and he knows a good chart when he sees it and gives it to me. EPA has approached setting these standards in the following way. What it's doing is determining stringency. How tough is the standard going to be? So it takes an approach that is called the building block approach. It uses 4 building blocks. The first building block is this. It looks at each coal-fired unit, looks at coal-fired units generally and says, how much can they improve at the unit through heat rate improvements, to improve their efficiency? So what kinds of equipment upgrades or best practices or co-firing with other fuels, what can we do at the unit itself that will actually improve the efficiency of the coal-fired electric generating unit? And that it sets as a rate-based standard to start with. And it is concluded that on average, they can improve their efficiency up to 6%. EPA then looked at another building block. Again, this is informing the stringency of the standard. It said, what additional emission reductions could be achieved if we essentially displace coal-fired generation with more natural gas-fired generation. So we take the cleaner fossil source and we use more of it and less coal. And they calculate this using a capacity factor of 70% on the theory that right now we're underutilizing natural gas. So we could use about 50% more natural gas than we currently use. And what EPA is looking at is how much emission reduction could we get if we used more natural gas, less coal. The third building block is they ask the question, how much reduction could we get, reduction of CO2 emission, if we used more renewable energy, if each state were able to deploy some renewable energy. In addition, how much benefit will we get, emissions reduced, if we kept online the existing nuclear fleet. So we don't retire nuclear, and any planned new nuclear, because a few states have planned new nuclear, were to be completed, how much benefit will we get from that? And the final building block is, what about end-use efficiency? If we actually invest in more efficiency, it will reduce demand across the board for any generation, and so we'll have fewer emissions as a result. What EPA does is, it calculates for each state, depending on its own existing energy mix at the time. How much coal does it have? How much natural gas potential does it have to displace the coal? How much renewable potential? Although that's not state by state, that's calculated on a regional average, but we'll get to that later. But it's basically asking this question for each state. How much can they get out of each of these building blocks? And then it sums that together in a complicated kind of adjusted rate process, which it has a wonderful tool on its website that you can walk through and do this for any state. And the end result is to produce an emission target expressed as pounds per megawatt hour of intensity target for each state. And now I want to go back to my slide that I liked. This slide shows you that process for each state. It shows you the building blocks for each state. Here's how it works. This gray bar, the top of the bar represents the target that each state has. And above that, in each column, what you're seeing is what share of each building block has been projected for each state. So the red is the coal heat rate improvements at the coal-fired units themselves, what they can do on-site at the unit. The pink is substituting gas in for coal. This bar, the yellowy gold bar, nuclear, renewables is light blue, and more efficiency is the purple, as you see. So this shows you for each state what their target is and how they get there based on the building blocks. Now, we go through this in detail because the methodology presents the hardest legal question, which we will talk about shortly. But what is an important takeaway for you right now is to understand that this process of building blocks doesn't actually tell any state what to do. This is really important. A state can comply with its emission rate target, its intensity goal, doing anything it wants. It can do more of any of those building blocks or less of any of those building blocks. It can come up with something different entirely. EPA has just set a target using this method, and the state has the flexibility to do what it wishes. Okay? So the controversy is this. Here is our representation of the first building block. That is what you can do at the units themselves. What can you do to improve the heat rate improvements of the boilers or turbines? This, though, represents the other three building blocks, which are outside the so-called fence line of the plant. And that is, what can you accomplish because things are interconnected via the grid by substituting in natural gas, bringing on more renewables, keeping in place your nuclear, and adding end-use efficiency. That's the methodology EPA used. I think that brings us to the rationale. What's EPA up to? What's motivating its interpretation of the law to allow it to approach these standards in this particular way? The regional grids are interconnected, as you all know. What EPA has done is said, look, there is some opportunity to reduce CO2 emissions from the existing fleet of power plants by tinkering with, by upgrading and improving the efficiency on site. But there are many more cost-effective reductions that can be achieved by taking advantage of what you can do across the interconnected network that ultimately affects the total emissions from the entire system seen as a whole. And that means dispatching more cleaner fuels, more low and zero emitting fuels, and introducing more renewable energy and end-use efficiency. That's its rationale. The other piece of its rationale that I'll mention before handing off to Richard again is simply to say it views this approach as providing maximum flexibility for the states. Once the target sets, the states have at it. They develop plans, they do what they wish. So this observes a principle of federalism that's very important. leave states flexibility. And the other important animating feature of this is it invites states to use cap and trade and to do this across regional planning, multi-state plans. Because if states recognize the most effective, low-cost, effective reductions are going to be achieved by off-site investments in efficiency and renewables and natural gas substitution, then it'll be cheaper for them if they join hands together and do it through a trading regime. It doesn't mandate it, but it invites it. So this is why EPA thinks it has come up with a creative and economically rational approach.
It is a beautiful rule. It is incredibly creative from many different perspectives. And then the question is whether it's legal or not. And it's really important to remember, and people forget this all the time, right? Not everything that is good is legal. Not everything that is bad is illegal. Not every time a court rules against you is that judicial activism. There actually is something called law. And the law does present some boundaries in terms of activities. All right, so what's the legal boundaries for EPA here? It's the Clean Air Act, right? The court said EPA has authority in the Clean Air Act. That's why there's not the nuisance. So it's the Clean Air Act which decides it. And in particular, it's Section 111D. That's the provision which gives EPA authority to regulate existing stationary sources. So EPA has to find its authority in this provision, in this language. And to win here, EPA has to either say that this language unambiguously authorizes us to do it, or they have to say, look, all right, even if the language is ambiguous, it's not clear, we think we can reasonably construe the language this way. The origins of this test of an agency's authority under a statutory provision is from this case, 1984 decision by Justice John Paul Stevens called Chevron v. Natural Resources Defense Council. And in this case, what was at issue was a Clean Air Act case, although it's actually one of the most significant Supreme Court cases ever, one of the most significant administrative law cases ever. It's a Clean Air Act environmental case. And here's what was at issue in Chevron. There's the statutory language. There's EPA's regulation, which is their interpretation of the statutory language. EPA wanted to interpret the meaning of the word stationary source in the Chevron case. Stationary source means any building, structure, facility, installation which emits or may emit any air pollutant. EPA wanted to construe that language to say, well, stationary source, we think we can construe it not to require us to regulate every individual stack on every individual facility. But we think instead we can treat multiple stacks on a single facility or multiple stacks in an area, contiguous area. We think we can treat that as one stack. We can in effect bubble it like this. So we have a facility like that. We don't have to regulate each of those stacks separately as sources. We can regulate them all as a bubble. The EPA said if we do that, it'll be much more efficient and much easier practically for us to do it. And in that case, the Chevron case, the court had to review whether EPA had authority to do this or not. And the court in that case announced what's called the Chevron test. It's the two-step test. And they said to answer that question, whether agency construction is permissible, we're confronted with two questions. The first question is whether or not Congress has directly spoken to the issue. If Congress has directly spoken to the issue and the intent of Congress is clear, that's the end of the matter. That controls. The agency can't come up with another interpretation. That interpretation wins. But if the language of the statute doesn't show that Congress has directly addressed the issue, then the question for the court, the agency's answer is based on a permissible construction of the statute. So if it's ambiguous, it's a different test. And then the court filled that out even more and said, when it's ambiguous, we think that Congress, in effect, delegated to the agency some policy-making authority, some law-making authority to do it. And we'll uphold their regulation, that legislative regulation by the agency, will give it controlling weight unless it is arbitrary, capricious, or manifestly contrary to the statute. So the court announced that test in Chevron, and then the court applied it to EPA's interpretation in that case, to its bubble. And it concluded this. We think Congress didn't have a specific intention on the bubble question, and we think EPA's use of that concept here is perfectly reasonable. This has been a very powerful doctrine for EPA. EPA wins many cases because of this deference. If they can say, even if the plain meaning doesn't support us, it's a reasonable construction of the statute, the policy-making authority Congress has given us. That's going to be a very important case in this litigation. And actually, just last term, April 29, 2014, EPA won a huge Clean Air Act case in front of the United States Supreme Court. This was a case involving the validity of one of EPA's most important rulemakings ever. And that is a rulemaking designed to deal with interstate air pollution. And there was nothing easy about this case, nothing easy about the statutory language in this case, and whether EPA was violating the language or not. In fact, EPA had lost on this issue several times before the D.C. Circuit and kept trying to try again. The D.C. Circuit said, once again, you've lost. They got it in front of the United States Supreme Court. The United States Supreme Court, last term, applying Chevron, said, you're right, you can do this, EPA. They said, we don't think Congress answered the question. We don't think Congress answered the question here, and we think you have enough room here to wiggle. And we think your construction was within bounds. All right, now let's look at some of the legal issues actually that are going to be used to challenge this particular rulemaking. I'm going to mention a couple of them, and Jody's going to move to an additional one. Here's the first one, and this is the kind which only a law professor could love. So the statute 111D1 actually says, right, you can do this, you can regulate any air pollutant from these sources, right, as long as it's not included on a list published under Section 112B1A. That's what it said when the statute passed in 1970. That was the original language. And what is 112B1A? That is a provision dealing with regulation of hazardous air pollutants. So basically what Congress said in 1970 was, you can regulate these existing sources under 111 unless, right, it's a pollutant, which is a hazardous pollutant, being regulated under 112. Because we want those to be regulated under 112 and not under 111. Made perfect sense. And then this is what happened. In 1990, Congress did a whole series of amendments to 112. And they changed some of the letters and some of the numbers around, and to change B1A was different than it was before. So they needed in 1990 a technical amendment to sort of deal with the fact that B1A no longer referred to the same thing it referred to in 1970 when the language was still passed. So they needed to get rid of that. And what happened was the Senate passed one version of how to change it. The House passed another version of how to change it. So here's how the Senate said we should change it. The Senate said change it by taking out 1A, right? That's easy, because B1A no longer is really there anymore. Let's just make it 112B. That'll achieve technical amendment, same thing. The House, on its side, passed different language. They said, well, I think we should change it by taking out these words and adding these words down here. Now here's the problem. If you follow the first one, the Senate version, it means that if the pollutant is regulated as hazardous air pollutant, you can't cover it under 111. Well, greenhouse gases are not a hazardous air pollutant, no problem. You can regulate it. But the second one says, if it's an air pollutant which is not emitted from a source category regulated under Section 112, then you can't. This language seems to basically exclude from Section 111 any source category that's regulated under 112. Well, guess what source category is regulated under 112? Power plants. Not greenhouse gas emissions, but mercury from power plants. But if you follow that language, it means that EPA can't regulate power plants under Section 111 because they're regulated under Section 112. Meaning EPA would have no authority to do any of this at all. Now, normally, as many of you know, if you've taken like basic, right, high school, right, civics, the House passes its version, the Senate passes its version, and what happens? It goes to conference. And in conference, they settle on one version, and that version is the conference substitute, and it's passed by the House and the Senate and signed by the President. Well, it didn't quite work that way here. Instead, they didn't realize they had passed these conflicting language. So each passed the House and the Senate in different parts of the same bill. One part of the bill said change it this way, another part of the bill said it changed it this way. They both passed, both chambers, they were both signed by the President of the United States. So the question is what to do about that? Well, you can rest assured, industry is saying, that's law. Right? You can't do that and you can't do that. That's law. You can't regulate power plants under Section 111D1. So all this stuff is illegal.
And Richard, as you point, this version that industry likes appears in the United States Code.
Right.
Even
It
though
actually
both
appears in the U.S. Code. Each one is equally forceful. But for some reason, the people who wrote the code actually picked this one over that one.
They got there first. It came first in the order.
But actually, that has no legal significance, what's in the U.S. Code. What matters is what actually passed Congress. But they both passed. So industry is going to say, we win, plain meaning the statute. Chevron won. We win. But EPA is saying, well, they passed both. That means congressional intent is ambiguous. And therefore, we win, because it's a permissible construction of the statute. That's just a big threshold mess of an issue. But it's the ball game if EPA loses on that one. The next issue that I want to mention is this one. And that is the Clean Air Act, Section 111D, says administrators shall prescribe regulations. But then look what it actually says. Under which each state shall submit to the administrator a plan which establishes standards of performance. EPA construes this language to mean we can decide what the emission rates are for each of the states. A lot of the states' industries say, no, that's not what it says. It says you can establish procedures by which the states will decide what the emission rates are. They're supposed to decide the standards of performance, not EPA. There again, plain meaning or ambiguity.
Those are just the threshold issues, right? You have to get through those to get to the really hard questions, which are coming now. We actually think there are good answers to these questions. We think EPA is on pretty solid legal foundation, and you don't hear industry hitting these two threshold questions too hard in a serious way anymore. They do for public consumption.
But they wouldn't mind if it sticks somewhere.
They'd like it, but we think that that's actually not the hardest thing. This is the hardest thing. The hardest thing is what's a standard of performance under Section 111D. So bear with me and think back to my building blocks from before. The question is whether EPA can set a, quote, performance standard, looking at not just what an individual unit can do to improve its efficiency on site, but also considering the emission reductions you get from using lower emitting generation, from substituting natural gas for coal, adding renewables, and even using end-use efficiency. The stringency of these targets is driven by all of those considerations, and this is what people call the inside the fence line, outside the fence line legal question. That is, can EPA define standard of performance to be something you can set based on not just what a unit can achieve on site at the facility? The actual definition of this in the Clean Air Act, Section 111A, standard performance is defined. Congress says it means a standard for which emissions of air pollutants which reflects the degree of emission limitation achievable through the application of the best system. It is a standard achievable through the application of the best system of emission reduction. And EPA's position is, now you're with us, because now you know Chevron, right? Now you've been through administrative law in law school. EPA says, plain meaning, Congress says a standard of performance can rely on the best system. Well, the interconnected grid is a system. So when we look to set a standard based on what the best system of emission reduction can achieve, we don't just look at the facility, we look at everything that creates demand from the facility. So we can go beyond the fence line. And it turns out the end of the sentence is the best system of emission reduction which the administrator of EPA determines has been adequately demonstrated. And EPA's position is, we see what end-use efficiency does to demand, it drops it. We have lots of states that have been experimenting with this. We have lots of states which have renewable portfolio standards that have demonstrated what renewables can do. We have seen that all of these techniques and strategies have been demonstrated. So EPA's position is its broader approach that goes outside the fence line to setting stringency. This is, again, the legal question, guys, is what's a performance standard? And traditionally, under the Clean Air Act, in this program that sets standards for categories of industrial sources, power plants, oil and gas refineries, pulp and paper mills, et cetera, traditionally EPA has set rate-based standards for those facilities, for those units, meaning amount of pollution per energy output. So it's a rate-based standard that really attaches to the unit, to the particular facility itself, and the idea is that traditionally what sources have done to comply is they've put on equipment upgrades, scrubbers, they've done things at the unit to comply with these standards. But that's true of the past. It doesn't mean EPA is precluded from a broader approach in this instance because the definition allows it and because CO2 and the utility sector lends itself to a system-wide approach where you don't have to care so much where the emission reduction is coming from as long as it comes from the interconnected network. So this just summarizes EPA's legal approach. That is, it starts with the building block that is, what can you do to reduce emissions at the unit, and then it expands to include all these other considerations, and all of that contributes to the stringency of the standards they have set for each state. This is EPA's legal argument. This is what it has said in the rule. It said, hey, just read it. The term system, best system of emission reduction, is actually helpfully defined for us in the dictionary. And that's actually, some justices actually rely very heavily on the dictionary. They're textualists like Justice Scalia, so this is not a crazy thing to do, to look at the dictionary. Plain meaning argument, this is the plain meaning of the text on its face. The term system, which is not defined in the Clean Air Act by Congress, is a set of things working together as parts of a mechanism or interconnecting network. That's what a system is. That's exactly what we're doing. We're looking at the whole network. And it's clear from these Clean Air Act provisions that anything that reduces the emissions of the affected sources, be with me now, anything that reduces the emissions of the affected sources may be considered a, quote, system of emission reductions for those sources. Again, this is how they define a standard of performance.
Yeah. So on its face, right, it's not a bad argument. I mean, it does say best system of emissions reduction. And system basically means anything connected. And you can say anything that reduces emissions, right? Can be adequately determined? That's enough. So that's great. The problem is, think through the actual practical implications of what it means. Anything that reduces emissions. Well, you can just, right, use less electricity. Just use less. If you use less electricity, and that can mean energy efficiency, it can also mean just using less of it. Anything that does it, that will reduce the hours these power plants operate, that will reduce emissions. The practical impact of it is a much broader extension of EPA's authority. They're only saying what these plants can do, but they're saying it based upon all kinds of things they say we all can be doing. It's a much more expansive assertion of authority to say how people in the United States should reduce their energy demand, how end users should do it, how buildings should do it, to what extent renewables should do it. And they're doing all of this based upon, right, the language in 111D. Best system emissions reduction. It is a very, very, right, broad, unprecedented assertion of agency authority with some language. But it's the kind which is unusual. It displaces, not displaces, but it's the kind of thing states and local governments have done, or people have thought the federal government can't tell us directly or indirectly what to do. And the classic example is they're going to tell me, in effect, I've got to use a certain kind of light bulb in my house. Not directly, but indirectly, if the states are going to achieve these kinds of emission caps. So it's a very, very broad assertion of authority.
The strongest sort of narrative, I think that this might be how this might be expressed as a narrative might be EPA can't decide the energy mix for the country. It's a pollution regulator. And suddenly, this expansive interpretation Richard described makes it an energy regulator. And there's something wrong with that. It's gone beyond its authority. And we gave you a lot of the happy news when we talked about the Chevron case and agencies getting deference for their interpretations of ambiguous laws and how well EPA's been doing in its Clean Air Act litigation, winning here, winning there, winning everywhere. And that was all the happy talk. And now comes the unhappy talk. Based on the UARG case that Richard mentioned earlier, the Utility Air Regulation Group case that came down this summer from the Supreme Court, while it was mostly a win for the EPA, it mostly meant that the regulations EPA has issued so far to control greenhouse gases will survive. It wasn't all bright spots. There were a few dark moments, and in the opinion, there are warning shots. It's hard not to view them as that look like they are designed to make EPA sit up and take notice. Here's some of the language from the decision, which again largely upheld EPA's rules, but on one important issue struck down EPA's interpretation and said that the statute precluded it. EPA's interpretation is also unreasonable because it would bring about an enormous and transformative expansion in EPA's regulatory authority without clear congressional authorization. If you're reading this at 5 o'clock in the morning on the day this decision comes down, you start massaging your temples. Then the court says, later in the same opinion, when an agency claims to discover in a long extant statute an unheralded power to regulate a significant portion of the American economy, we typically greet its announcement with a measure of skepticism. Again, kaboom, this is a warning shot. And the cite here, interestingly, is to the Brown and Williamson case, which Richard and I both know is a very specific reference to the case in which the Food and Drug Administration sought to regulate tobacco and nicotine under its existing Food, Drug, and Cosmetic Act authority. And when the FDA sought to, for the first time ever, extend its authority over drugs to nicotine, the Supreme Court held in this case that was such an expansive assertion of heretofore unrecognized authority, of such economic and political significance that that had to come only from Congress speaking clearly.
Even though the language seemed to cover it.
Yeah, drug.
Nicotine.
So this, as we've discussed between us, this, the power plant rule is more Brown and Williamson than Brown and Williamson, in a sense, because if you think about the expansiveness of what EPA is proposing to do, it's asserting authority over the entire utility sector, setting standards for every state that has the potential, if it were implemented, to transform the energy mix, right? So there's some danger represented by this language, and on goes the court finally to say, we expect Congress to speak clearly if it wishes to assign to an agency decisions of vast economic and political significance. This is why, although there is lots of good news for EPA in recent Supreme Court decisions, and why there's a strong history, long-established principle of deference to agencies interpreting the statute that have been entrusted to them when there are ambiguous provisions, and notwithstanding the historic Chevron case, there is reason to be concerned.
Right. It doesn't mean EPA loses, but it means EPA is going to have a real challenge in light of this language. A language which is in a different part of the AIR Act, but it sort of gives you a sense of at least, this was 5-4, at least 5 justices were thinking. And whether they are aware of this rule, which came out just a few weeks before, one doesn't know. One more issue I want to mention, which is going to come up in the litigation. And that is, but you heard how Jody described this incredible rule. I mean, it really is this unbelievably ambitious, creative, thoughtful federalism, disrespect to states, economic efficiency rule. Think about all the relevant facts that EPA has to find. It has to figure out what the mix is for all states. What they currently do, how much they can do through fuel efficiency, how much they can do through end-use efficiency, how much they can do through renewables. For every state, that's a lot of facts. So EPA is going to have to justify in court the percentages it allocates to all those states. And all those states and industries are going to be just picking it apart from every possible perspective. There's a lot of underlying facts. So EPA is going to have to show that their factual findings are sufficient. A whole separate set of issues the agency has to deal with. Now here, the good news is they have a very deferential standard review. The standard review is the agency wins as long as its factual findings are not arbitrary and capricious. So there they get deference, but still there's going to be an enormous amount of litigation associated with that, a huge burden for the agency to handle. A few concluding thoughts?
So I think what this communicates to you is this is going to be a hard case. This is a situation in which we have statutory language and an unprecedented interpretation of it. but not an unprecedented interpretation without some foundation. There's been a history of interpreting provisions to do things that maybe on their face you wouldn't think are necessarily clear or intuitive, but EPA has been given the latitude. And so what's going to win this case is, we can't resist saying this, really good lawyering. It turns out you have to make really careful, nuanced, specific, well-crafted legal arguments, because there are arguments on both sides of this issue. And it's going to come down to whether you can convince 5 justices that the interpretation being offered is a reasonable interpretation of the statute. The signs from the court, Richard can speak to this, are not entirely clear. Justice Kennedy, the swing justice, voted with the 5 in that utility air regulatory group case and voted for all that language, signed on to all that language that was a bit chastising, right? But at the same time,
Massachusetts versus EPA.
he signed the majority opinion. He was the 5th vote in Massachusetts versus EPA, which opened up all of this potential by finding the Clean Air Act applies to greenhouse gases.
Justice Kennedy is a swing justice, you all know, in most cases. Environmental law is no exception. He's been on the court since the late 1980s. He's been in the majority in every single environmental case before the court except one. He tends to be bellwether for the court. But in the first instance, while litigation is preordained and already begun to some extent, it takes a long time for it to get to the Supreme Court, and not all cases get to the Supreme Court. Now, the Obama administration, what they're trying to do is get this rule finalized and get it litigated in the lower courts before, guess when? November 2016. So they want to get this rule out by next summer. They want to get it litigated in the D.C. Circuit, because the way the Clean Air Act works is issues challenging these kinds of Clean Air Act rules, there's exclusive jurisdiction in the United States Court of Appeals for the District of Columbia Circuit. They can't go to any other circuit, and they don't go to district court first, like everything else. They don't go to trial first. They go right to the D.C. Circuit in the first instance. That's why the D.C. Circuit is so important. And not coincidentally, because EPA and Obama knew this was coming through down the pike. That's probably partly why, about a year ago, the Senate killed the filibuster rule. And they changed the filibuster rule because they were unhappy with the D.C. Circuit, which had been ruling against them in several cases, including in some of the Clean Air Act cases. So they basically got rid of the filibuster rule for federal court appointees, appellate appointees, and they put on, in the last sort of year plus, 4 new appointees to which court? The D.C. Circuit. With the hope being that they'll have some judges up there who won't just be sort of knee-jerk against or for them, but will be receptive and not be necessarily hostile or skeptical to it. That was part of the reason why they did it. So the first instance will go in front of the D.C. Circuit. EPA may change the rule a little bit. It's proposed. They're going to read those million comments. And they may change the rule. Then a final rule, hopefully they think, will come out next summer, litigate in the D.C. Circuit. If they win, they're going to try to keep it away from the United States Supreme Court. If they lose, they're going to try to get to the United States Supreme Court.
Remember the other political dimension of this, too. There's a process unfolding in the international arena. It's not going terribly well or terribly quickly, but it's going. And this is crucial to the Obama administration's legacy in the sense that to make the U.S. credible in those negotiations, it has to demonstrate that it can do something at home to control GHG emissions. So this is hugely important to the future of international negotiations. And the last point to make is, the other reason the importance of this can't be understated is, if this succeeds, it's the first ever federal driver for state energy efficiency programs and state renewable portfolio standards and all of the things the states have been doing over the last decade or so to move the ball forward on greenhouse gas emissions. We have never had a federal rule driving this forward. This would be historic for doing that alone.
The last week, we've seen some of the most incredible inaction by the court, I guess, in terms of gay marriage. And one of the questions that is coming up in the reporting about this is the issue of how popular opinion and the swing in popular perception of this issue, really over the last 5 to 10 years, has changed the court's opinions. The question is, how much do you think popular action, protest, activism, but also just a variety of political polls will matter 2 or 3 years from now when this actually gets heard by the court, or do you think they're immune to that?
I think most of them are fairly immune from that. There's one who's less immune from that,
Luckily.
Justice Kennedy. Justice Kennedy actually has a very strong sense of himself, of his role in history, a very enlarged sense.
Recording.
I know.
Okay.
It's the advantage of what we call tenure.
For him too, by the way.
And so I think that those kinds of issues, I think, do matter to him more than others. I don't think he's so worried about sort of, there are things he's done on issues which is very controversial the other way. So he doesn't care about everyone always loves him. What he does do is he likes to be important. That's more significant than anything else. And so if the issue is more important and more historic, Kennedy likes to step up to the plate. And that's probably what happened with the decision on Monday, 2 days ago, where the court surprised everyone by not taking the gay marriage cases. My guess is because that the conservatives, who are the ones who would have been voting, because the lower courts had mostly gone to say that the bans on gay marriage are unconstitutional, conservatives weren't yet confident where Justice Kennedy was going to be. It takes 4 votes to grant review. They knew they could grant review with 4, but they needed to win with 5. So they weren't confident yet of where Kennedy would be. If they were confident that he'd be with them, they would have gone and granted review. The liberals, if they had been confident that Kennedy would have been with them, they would have grabbed the moment, and the 4 of them would have voted for review. But both were sitting there not sure what Kennedy was going to do. And Kennedy probably is sitting there saying, he's more, in terms of opinions, more favorably disposed sort of the gay rights and gay marriage than not. He's a little on the fence on when the court should step in and answer the question, as opposed to the states step in. And Kennedy probably likes to see all this development happening in the courts. And the longer he sees this development, more likely he'll go that way. But he wants to see the lower courts fill things out even more. And so that's why I think you saw him step aside.
Dan, in response to your question, let me say something controversial which follows on Richard's remarks, and that is, and it's against the tenor of our talk, which is focused on law in the courts and how the rule will do, and that is, EPA is not really playing for the court.
Right.
The administration is not playing for the court. The administration clearly, and I'm not reporting what I know, I'm reporting my suspicion. The administration, I think, has made a decision that it's time to go big or go home. We're not here in the last few years to do little tinkering stuff around your boiler. We're here to do something transformative. We think it's legally sustainable. We do. And we've thought very hard about it and produced pages and pages of defense for it. We're going to argue our hearts out. But if it gets struck down, things will have happened in the interim, as Dan said. Things will have shifted. People will have gotten used to these ideas. States have already begun to start experimenting with these measures. And in fact, in the process of writing the rule, there was a lot of exchange between EPA and the states on what could be done, how to improve things. There's motion. They're playing for movement down the field. They're going for downs. And if in 2 or 4 or 5 years this gets struck down, things will have changed. There'll be a new president. They can't predict the future, but they're not going to do something small and wait for something bigger.
Well, and obviously they think, right, many people do, this is a huge, compelling problem.
Yeah.
And they don't want to wait. They don't want to be conservative and do something small, which increases the chances of winning. They think, this is it. This is our moment. We are in power. We have EPA. We have administration who wants to do this. It's taken a long time to get these players all together in the executive branch. We didn't pull it off in the legislative branch, but this is our moment. Let's not underachieve. Let's reach as far as we can.
So, Richard, what about the fact that the EPA is not telling the states that you must do energy efficiency or you must do renewables? So, it's not like they are seizing authority over other areas. They're just giving states an option in other areas, but they're in no way regulating those areas.
But here's the tricky bit, which goes back to our fence line argument. The industry would love all this flexibility to use end-use efficiency, renewables, natural gas. They love all those building blocks. They just want them to be compliance options. They don't want the standard to be more stringent based on what those things can achieve. So the fight is about what counts for stringency. They love all this cost-effective stuff on the compliance side. And as to the question, I love your framing of it, which is the way that to win, EPA is going to have to frame it. We're not doing energy policy. I think actually the better formulation is we've always done energy policy. The formulation is pollution regulation, by its nature, affects the fuels they use in the utility sector. It always has. Power plants produce some of the most pervasive pollutants, SO2, SOx, and NOx. They're regulated for producing hazardous pollution, as Richard pointed out. There's an entire program in the Clean Air Act that deals with acid rain, which is focused on power plants. Everybody always knew, including in everybody Congress, that this would affect decisions by utilities about what fuels they were using and how to. So pollution regulation is energy regulation. And I think if the court begins to understand that, they'll see this somewhat differently.
The other reason they did it, and I think this was also somewhat strategic, and that is this is a country where we don't have just one big national government. We believe in strong state governments as well. And so they're trying to be deferential to states up to a point. And there's one justice in particular who cares tremendously about that
Luckily.
issue, and that's Justice Kennedy. Justice Kennedy talks all the time about states and the rights of states and states as sovereigns. In Massachusetts versus EPA, the reason why the court held that there was standing to bring that case, that actually you could bring the lawsuit, and he focused on this oral argument, was the fact that we had state. Massachusetts was one of the plaintiffs in that case, not just an environmental group, but a state sovereign. The one case, I mentioned that he had dissented in one case, in one environmental case since he's been on the court. It was called Alaska versus EPA. It was an opinion written by Justice Ginsburg. Justice O'Connor supplied the 5th vote, so Justice Kennedy's vote wasn't necessary for the 5. Justice Kennedy wrote a blistering dissent. And the reason why he was so mad in that case was he thought that EPA was disrespecting the states and disrespecting the states as sovereigns. So EPA knows that Kennedy is very sensitive to deference to states and the administration of the Clean Air Act. And that's why you see them singing that song. It's good politics, it's good law, and I think it's good policy too.
So I'll start and Richard can finish. It's clearly going to be both and both on both sides. So industry in the states have already filed a petition on the threshold issues we discussed. The EPA doesn't even have the authority in the first place to do any of this, so stop them now before they finish their rule. A number of states are going to be against the rule, and a number of states, particularly the Northeast states that already are part of the RGGI Greenhouse Gas Trading Program, California, all the predictable states you might imagine, your coastal states on average, are going to be for it, so there'll be a division. And there's clearly standing because the industry is directly affected by these regulations.
Yeah, just explain what standing means for the non-lawyers in the group is that in Article 3 of the Constitution, to bring a lawsuit in federal courts, you have to show it's a case or controversy. The Supreme Court says to be a case or controversy, you have to show you were injured, that you suffered injury in fact, and that this suit will redress that injury. So in this case, since industry is going to bring the lawsuit, and they're the ones who are being regulated, they're going to have no problem saying that they've been injured. And to the extent the states, some of the states are going to say that you're forcing us to do things, they'll have no problem getting standing. What's interesting about all these environmental cases is you have states on both sides. It used to be in environmental cases you had downwind states that were sort of looking for strict application of the Air Act and Water Act, and upwind states that were on the opposite, or downstream and upstream. Now it's more red and blue.
It's also energy mix. It's also clean and dirty.
That's right.
You know, this is a regional
Full states.
question. Yeah.
So the question is really about whether states can do nothing, and essentially what happens then if a state actually just doesn't cooperate and doesn't put together a plan.
So again, I'll start and you can jump in.
Basically, strictly speaking, it's sort of it's not a SIP because a SIP is for a criteria pollutant under the statute, and this is SIP-like, State Implementation Plan under 111D, which has a SIP-like procedure, but it's actually not a state implementation plan. Basically, in a lot of these instances, you cannot force. I mean, EPA cannot, consistent with what's called the 10th Amendment of the Constitution, EPA cannot force the states to do a lot of this stuff. What they can do is incentivize them to do it, and if the states, in terms of highway funds, the rest, and if the states don't, EPA can step in. But you're certainly right, and often in the Clean Air Act and the Clean Water Act, there's a little bit of game of chicken going on because everyone knows the EPA doesn't really want to step in and do it all themselves. And so the states could, in theory, say, all right, we'll call your bluff. Let's see you really do it. States have never really done that very much. A few times, but generally don't, because they're very worried about a ceding authority. They're very worried about sort of a federal government coming in. So they generally don't try to play that card. Instead, what they try to do is sue and say, you can't make us do it in the first instance, rather than sit back and take a chance that they might lose in court.
There's also, I think, a practical response, which is just that it's always possible that states will drag their feet and wait till the last possible minute, wait till litigation's over. But this rule doesn't appear in a vacuum. EPA has been regulating conventional pollution over time, too. The cross-state pollution rule that deals with migrating air pollution, as you know, and mercury and other air toxics. There's a standard for those that are driving improvements at power plants quite apart from greenhouse gas emissions. Now, there are co-benefits because they reduce greenhouse gas emissions, but those rules are already promulgated, they're issued, they're having an effect already, they're driving reductions. It's not as if utilities can sit around and do nothing. And so we're not in a static place where this rule is changing everything. They're already moving to try to integrate cleaner energy. States are being driven by a bunch of local factors too. This is just sort of driving things forward in a more targeted
One thing I want to add, because you mentioned co-benefits, and that is these regulations targeted at greenhouse gas emissions, if they lead to the kind of reductions they're talking about, it's not just greenhouse gas emissions which will be reduced. It's all the other pollutants that come out of carbon and coal will be reduced. And actually, there's a wonderful study, I think, put out by Harvard University scientists in the last week, some, I think, atmospheric chemistry professors, detailing the enormous non-greenhouse gas climate change benefits, the public health direct benefits of the reduction of emissions that would result from this rule.
I thought one of you might ask this, so here it goes. First of all, it's always possible to make the argument that each of these building blocks is far too conservative. In other words, when you say 6% improvement at the unit, a lot of the utility industry gasps and says, but we've made all the improvements we can make already to comply with these other rules. There's not another 6%. And others will say, oh no, there's up to 12%. So there's a debate about that. Same about the renewables targets. It's based on an average of the RPSs in the region. States are going to argue, RPS average in the region, our region only has one state with an RPS. Everybody else has a 0. So you know, that's too stringent. And the counter argument is going to be, well, people can do much more aggressive RPSs if they really put their mind to it. Same on energy efficiency. 1.5% annually is seen as unbelievably ambitious. How can we make those incremental changes? States that have done energy efficiency say, oh, there's way more energy efficiency out there than you. So you're right in principle, that's all true. But about the 2005 baseline, it turns out that the 30% reduction EPA says is going to be achieved by this is somewhat less than that if you compare it to the 2012 actual, as you said. It really represents the 17% from 2012 improvement because we've already improved from 2005 to 2012 by about the 13%. So but here's what EPA says, and Ari, please tell me if I'm wrong, because Ari knows this better than anyone. EPA's base case, just bear with, EPA's base case shows that without this rule by 2030, there will only be a 6% drop below 2005 levels. And the rule drives another 24% drop by 2030. That's what it claims based on a base case, because the rule drives down projected consumption growth. And without the rule, we'd have an increase in consumption growth. So that's where they get their claim. So it's really a claim to 24% better than would otherwise occur compared to 2005.
The only thing I'd add is I think the basic premise of your point, which is in some ways EPA may have sort of held back a little ammunition in this proposal. I think that's true. It's true to such an extent that actually industry expected an even far more aggressive rule than that. They thought there was one that was going to target 40% reduction, not 30% reduction. And they were so convinced of that, their initial press releases, when this thing came out, said, this is outrageous, requiring 40%. And actually the rule didn't require 40%. EPA did sort of hold back a little bit.
This is so great. You're just softballing us to death. I love it. I'll start you. So in theory,
it doesn't mean it's not a great question.
It's a great question, Mike. In theory, totally reversible. It's a rule. Administration comes in, reverses the rule, replaces it, repeals it essentially, replaces it with a new rule. Totally reversible. In practice, not so much. You've got a utility industry that's poised to make $2 trillion of investments in new infrastructure going forward over the next, 25, 30 years. They're making these changes now. They're making investments. Things on the ground are going to change as a result, not just, again, of this rule, but of all of the pollution rules of late. Once that is set in motion, it's not easy to undo. And so even the anticipation of this rule ultimately being implemented is changing the facts on the ground. I think it's going to be very hard to pull up stakes and say, we're not doing anything to the utility sector.
And this is what happens in environmental regulation all around, and that is once the existing facilities are forced to spend a lot of money, the last thing they want is those rules relaxed, because they don't want the new companies coming in to not have to do it. So they tend to have sort of a natural friction to it that way. Here's the bigger risk over the next 24 months. The next 24 months, it's going to be that there'll be efforts in Congress to put appropriation riders on appropriation bills to deny EPA any money to make these rules final. That is a fairly classic thing that members of Congress can try to do. You put it on an appropriations bill, which you think the president has to sign, that he can't veto, because it's doing something he really cares about. And that can be, basically funding military actions in Syria. So he's got to sign. And you make him sign it, and it says EPA can spend no dollars to finalize, to actually just sign the rule. That has happened. Congress has done that before. And that's one reason why they're paying attention to, among other things, the race in the Senate.
And yeah, Nate Silver has the Senate 60-40 Republican. That has implications for this rule.
60, not 60 votes. You mean 60% likely to take over the
Yeah.
Senate?
Right.
Yeah. Oh, no, yeah.
Yeah.
No, like 50, like what, 52?
52 or maybe
Yeah,
53.
sorry, no.
Yeah. Now, unfortunately, there are enough coal state Democrats that actually there are about 57 votes against EPA authority. It's very narrow. Holding 40 votes on this is not easy.
That's the thing. It's regional. It's not party. It's about your energy resources. That tells you how they're going to vote.
It's a lot closer to repeal than you think. Yes.
Truth is,
hey, be nice, Jody.
it can make a difference at the margin, but law matters. I mean, there is a reason why we have, laws have to pass. It's significant that we couldn't get climate change legislation passed. If they got it passed, it would be a different ballgame. But you can't just then say this is really important and really good. It's not going to be enough. It can be enough in a really close case. And it might make enough here in a case with someone like Kennedy. But it's not enough to fill big gaps. It can fill small gaps.
I disagree with your premise, by the way. I think it's one thing to say the science is fairly conclusive. It's only outliers who disagree with the thrust of the science. But I don't think it's equally clear that everybody thinks there's an imperative to do something. It's possible to have a kind of dissonance with this, to say, well, we shouldn't go first. It's going to be so costly. What about the rest of the world? What about China? It's really not about us anymore. So I'm not so sure the way the sincere commitment you have to it is actually as widely shared as you think.
And to give sort of an example of that, and this surprised me, you looked at Mass versus EPA. In Mass versus EPA, the opening line of Justice Stevens' opinion talks about respected scientists and how respected scientists say there's consensus about this. That was a hugely significant moment in a Supreme Court opinion. It almost looked like the court was taking sides on it and saying this is the right side. And then AP versus Connecticut case a few years later, in 2011, Justice Ginsburg, who's no slouch on this and actually probably believes strongly in climate change's importance, she is forced to drop a footnote to make it clear that there's another side on the scientific debate.
But to get votes.
To get votes. She had to drop a footnote, and I'm sure that was because some of the justices were mad that Justice Stevens had put that in opinion. The court actually taking a position, looking like taking a position on the science. So they wanted to make it clear they weren't taking it. She did not do that on her own initiative. She did that to keep a vote.
Although, Richard, in the amicus brief that I worked on for the AP case, the Connecticut versus AP case, we did highlight the damage that climate change will have on California wines.
Right.
Given Justice Kennedy's affinity for fine wine.
You can't make...
If you can show the damage it does to opera, you might get Scalia too.
Final question.
You cannot make this stuff up.
No, it's not a joke. Actually,
it's all true. It's all true.
So how is the EPA overstepping their authority?
The argument that they're overstepping the authority is that the Clean Air Act is about air pollution, and EPA throughout the law is empowered to set a set of standards, concentration limits for a limited number of pollutants so that we have national ambient air quality standards, and then performance standards for certain other programs to deal with other problems, to technology-based performance standards. And that's what it's in the business of doing. It's in the business of protecting public health, primarily health and welfare, so property damage too, but mostly health. And that does not encompass determining the energy mix for states. We have an agency called FERC, the Federal Energy Regulatory Commission. It has authority over transmission.
But limited authority.
Right, over interstate transmission and wholesale rates of power. It doesn't have the power to regulate the utilities in the state. It doesn't have the power to regulate the delivery. It doesn't have the power to regulate the choice of fuels. And so there's a regime, somebody would say. There's a regime. There's limited federal authority. It belongs in another federal agency. And don't basically stay in your lane. It's a lane argument. And I think the only way to break that, I think this is a very powerful narrative. Richard and I have talked about this. I think it's a very powerful narrative to stand up in the Supreme Court, never mind the legal argument, but the framing, and say they are out of their lane and they're crazy. Yeah. Versus, actually, we've always been in this lane. We're doing nothing terribly different than we've always done, and these two things, environmental and energy regulation, are intertwined. That's a very different narrative.
And we've always taken into account energy efficiency and our pollution regulations and the rest. So that's that narrative. The response basically is going to be, yeah, they're related. But you've never asserted such sweeping authority over that other part before.
Yeah.
You're taking the relationship and now you're making this your focus. And maybe you should have that authority. But when you assert a brand new authority under a, quote, long extent statute, then we want to hear Congress speak more clearly in the first instance.
There's a famous phrase.
We want to make sure Congress really wants you to do this. Maybe you should, but you get Congress to tell us.
There's a famous phrase that encapsulates that, and it's from Justice Scalia in another Clean Air Act case. You would think the law books are all filled with Clean Air Act cases. Justice Scalia said, Congress doesn't put elephants in mouse holes. It doesn't give you wide sweeping authority and hide it in little obscure provisions nobody's ever heard of. And you watch, because as this litigation proceeds, everybody's going to be talking about the elephant in the mouse hole.
I think that's a good place to end. Please join me in thanking Jody and Richard.